Hello class, this is Professor Smith, and this is an overview of the college level examination programs, Introductory into Business Law. We will be covering 6 units ranging from the history and sources of American law to contracts, the legal environment, torts, sales, agency, and the legal system. We're going to begin today with a look at the first unit. We are looking today at history and sources of American law. Now, when we talk about the origins of the legal system, we need to talk about what law is. And law constitutes a set of rules or principles established by the government or authority, controlling body, if you will, that the members of society must follow. And then that brings into consideration what the legal system is, essentially a system of established laws. And laws include rules and principles established by cases and statutes. Both the law and the legal system are designed to promote fairness, consistency, and order within society. We're first seeing laws created in 1792 BCE in Babylon. Code law is what we're seeing in these early civilizations, otherwise known as civil law, and these are based on a single comprehensive code in which the laws were formed around and referenced in therefore. Most countries follow some form of civil law system, with codes having their roots in the Roman Empire. Civil law is distinct from common law or case law because case law or common law are laws made by judges. These are judgment laws where judges make decisions on a case-by-case basis, and the decisions generate a body of rules and principles for the law system and legal system to follow. A judge in a common law system would reference previous decisions to make decisions on a current case, while a judge in a civil law system would reference a set of codes to make decisions. Civil law and common law represent the two dominant legal systems we see throughout Western society primarily. Most countries that were under English control at any point in time operate a common law system, while most other European countries, we're talking about France, Spain, Germany, and going beyond Europe, we're talking about Latin America, we're seeing a code law system. And common law is really based on the idea of precedents, which are previously made decisions in the legal system. And judges in a common law system are bound to these precedents. And due to the fact that they're set by previous decisions, it makes sense why we're seeing that in a common law system, because it creates a consistency within the system, which is helpful to keep order and balance. And when we start to talk about this idea of precedents and making decisions, we need to talk about the idea of stare decisis, the notion that judges make decisions consistent with precedent. Now, stare decisis is meant to promote certainty and consistency among courts and case law. Stare decisis encourages judges to follow the directions of the courts with equal authority, even of the courts of lesser authority, equal authority, or higher authority. Stare decisis means that previous decisions made by one's own court are rarely overturned unless the previous decision clearly violates principles of judgment and fairness. Pardon me. Now, we can start to talk about the Constitution. Articles 1 through 3 establish our 3 branches of government. Article 1 establishes the legislative branch, our bicameral legislature made up of the higher house of the Senate holding 100 members, 2 from each state, and our House of Representatives consisting of 456 members. That number may or may not be accurate. Representing the broader and more statistically accurate United States, with representatives from larger population countries, states, having more representatives, and those that are smaller having less. Our second amendment provides us, our second article, establishes the executive branch and gives power to the president, vice president, and administrations, and gives them power to enforce the law. of the land. Article 3 proposes the judiciary branch and establishes the Supreme Court as well in doing that. And it gives them the power to interpret the law. And they have the power to review federal and state laws to ensure that there are no violations of the Constitution in occurrence. Judicial review was established in 1803 as a result of the case of Marbury v. Madison, in which this decision has given the courts the ability to declare a federal or state law unconstitutional and thereby invalidate it. The Constitution establishes a system of checks and balances which provides each branch of government an ability to check the other branch's powers if they are getting too out of hand or exerting too much power or going beyond the limits of their constitutional powers. We can start to talk about the Constitution as well. There are currently 27 amendments, but the first 10 are known as the Bill of Rights and are meant to signify or they were aimed at protecting citizens from the government, intrusions from the government, and prevents the government from making any laws that interfere with these fundamental rights. Congress, as granted by the Constitution, has the power to enact federal statutes. However, these must be what are known as necessary and appropriate. Federalism is a system in which the United States operates under and is consistent of a mixed or compound mode of a government that combines a general government with regional governments in one singular system, dividing the powers between the two. This is what America operates under. We see that each state has considerable power in governing their individual citizens. However, certain powers are remaining in the hands of the state, while certain powers are granted in the hands of the federal government. Article 6 of the Constitution states the Supremacy Clause, which has been interpreted to mean that state constitutions and status cannot violate the federal constitution or federal law. Local governments can pass laws known as ordinances, which are aimed at solving local issues such as parking or traffic. Uniform laws, these are laws aimed at creating consistency between states on laws of similar topics. We are looking at these laws because they are created by experts, and each state is given the opportunity to enact these laws either in full or in part. And one of these most prominent examples of a uniform law is the Uniform Commercial Code. We'll talk about it a lot later, otherwise known as UCC. This is a prominent uniform law that provides legislation covering a variety of topics of commercial law, and this has been adopted by all states. Now we can start to talk about constitutional law. The Constitution provides for amendments such as the first, which has established that there will be no law with respect to religion or freedom of speech, which has then been interpreted to mean that there will be no official religion of the land, and the law may not infringe on a person's ability to exercise their religion. For free speech, Congress may prohibit speech that has a clear and present degree of danger in terms of its ability to incite violence, or anything that would create negative consequences. Now, commercial speech, this is speech regarding commercial economic activities. Congress has a wide ability to regulate commercial speech. The Supreme Court has allowed no restrictions on Congress to regulate commercial speech that concerns illegal activity or that is misleading. Regulations to commercial speech outside of that, that's illegal or misleading, will be deemed unconstitutional unless they directly advance a government interest and are tailored to serve that interest. Government regulations based on content are subject to strict scrutiny. They will be sustained only if they are narrowly tailored to serve a compelling government interest. Content neutral, which is essentially meaning that the restrictions referred to as time, place, and manner restrictions, which are subject to intermediate scrutiny. This is restrictions that need to be narrowly tailored to meet an important government objective. Now, due process is a constitutional right mentioned in the Fifth Amendment. Now, Fifth and 14th, I should say. Now, due process is essentially meaning that no person shall be deprived of life, liberty, or property without due process, or as the court describes it, the right to receive notice of any actions that would deprive a person of life, liberty, or property, as well as the right to have an opportunity to present a case in a fair procedure before a natural decision maker. This is why due process governs criminal trials, because they may restrict a person's life or liberty. The 5th and 14th Amendment mention due process, with the 5th applying it to the federal government and the 14th applying it to statutes. The Supreme Court found that both of these protect the same interests. Takings refer to the government not being able to take the property of an individual for public use without just compensation, as mentioned in the 5th Amendment. And when we talk about equal protections, this is the 4th Amendment clause, the 14th Amendment clause, providing that no state shall deny any person the equal opportunity of the law. This applies to states by the court, and by the court, it has interpreted it to mean that the federal government cannot deny all persons equal protections. Now, discriminatory law is law that differentiates people. Now, to be deemed discriminatory, it must be factually discriminatory because on its face, it distinguishes people. It distinguishes because of groups of people. It distinguishes between groups of people. I apologize. Now, it also must be applied in a discriminatory manner, meaning that it needs to be applied differently to different groups. And it needs to have a discriminatory purpose. Now, the court divides people into 3 classes involving, when law involving equal protections are present. There's the suspect classification, and this is being applied to strict court scrutiny. This classification is based on race, religion, national origin, or alienation, or any otherwise fundamental right. For this type of case, the government must demonstrate that regulations are narrowly tailored to serve a government interest. Regulations that must satisfy strict scrutiny are almost always found to be unconstitutional. Then we can move on to quasi-suspect classification. This is based on gender and legitimacy. The court applies intermediate scrutiny. That regulations will be valid so long as they are substantially tailored to meet an important government interest. This is less exacting and means that regulations have a greater chance of surviving when attempting to deem their constitutionality. And the last is our rationale basis test. This is all other classifications, pursuant to which the government relations will be upheld so long as it is rationally related to a legitimate government interest. That has been part 1. This is talking about the history and sources of American law. Next, we will talk about American legal systems and procedures. Thank you very much.